If you have been injured in an accident and your case progresses through the litigation process, the defendant has a right to what is commonly known as an independent medical examination, or IME. The reality is the independent medical examination is far from independent. The doctors who typically perform these type of examinations are paid very well by the insurance industry and go out of their way to reach conclusions that serve the interests of the defendant in the case. In other words, they are for the most part advocates for the defendant. Some of them earn most of their income from defendant examinations, as opposed to the actual treatment of their own patients. Typical conclusions that attempt to undermine a claim is the injured person has no objective findings of any degree of permanent injury or disability, or sometimes even try and say that the claim of injury is not related to the accident. It's important that anyone being examined in a defendant physical examination voice all their current complaints. During any range of motion examination, it's important to voice pain or discomfort at any point in the degree of movement when it is felt. Many of the physical examinations request that you bring medical documentation with you. We commonly instruct our clients to refrain from bringing anything other than their identification. If the examining doctor reaches a conclusion based in part upon an incomplete medical file, then the failure to have a complete file can serve as a basis for cross-examination at trial. It is also helpful to have a witness present who, if called into court, would make a good appearance and would be willing to testify as to the nature of the examination and specifically the time of the examination from the moment it begins to the moment it ends. It's common for the examinations to be extremely short, but yet the report written commonly gives the false impression that the examination was detailed and took a long time. In fact, many of the physical examinations take less than 5 minutes, but the reports are many pages, much of which is boilerplate portions of a physical examination that may not even have been performed. Physical exaggeration of an injury during an examination can undermine the claim, as an examining doctor is likely to conclude that claimant is exaggerating. Credibility is key to any case, and it is nothing that one wants to lose at any point in the litigation process. Examining doctors often comment on range of motion exhibited before and after the examination when the claimant is either disrobing or dressing. In other words, physical ranges of motion should be consistent in the examination portion of the exam, as in all conduct either before or after the examination. Lastly, do not submit to any type of X-rays or medical testing without the consent of your attorney. A defendant physical examination is nothing to fear or worry, but it is an important part in the process of your case.